get ready to start the meeting at this point. Okay, good afternoon, everyone. It's Wednesday, July 21st, 2021, and I'd like to call to order the meeting of the Connecticut Code of Evidence Committee. I'll start by taking the roll call. So when I call your name, if you could please just indicate that you're here, I would appreciate it. Justice Ecker? Here. Judge Goodrow?
Here.
Judge Youngblood?
Here.
Judge Prescott?
Here.
Attorney Edelman?
Here.
Attorney Brookman?
Here.
Attorney Costello?
Here.
Attorney Gaylor?
Here.
Attorney Goulash? And Attorney Steigelfast?
Here.
Okay, I'll note for the
And Your
record
Honor,
that
we also, I'm sorry to interrupt you, Your Honor. We also have present the reporter of judicial decisions, Eric Levine, and we have Professor Julia Simon Kerr as well.
okay, thank you. I will also note for the record that members Judge Mascott and Judge Morgan and Judge Sheldon all informed me that they wouldn't be able to make it to this meeting, but they are members of the committee. Okay, so our first order of business is to approve the minutes of our prior meeting. Has everyone had a chance to review the minutes?
Yes.
Any additions or corrections to the minutes? Seeing none, is there a motion to approve the minutes from the prior meeting?
So moved.
We'll take Judge Prescott. Is there a second?
Second. Mike Gaylor.
Mike Gaylor, any discussion? Seeing none, the minutes from the prior meeting are approved. So moving on to the second item on the next item on the agenda is to deal with some of our old business. I'm going to collapse that into my opening remarks. The opening remarks are not extensive. I'm just happy to see everyone. Glad we could all be back together, and hope for our next meeting, maybe in the near future, we can be in person and be able to do these meetings the way that we used to be able to do them. So with that said, we will move on to the main topic of our meeting, and that is a discussion of the statute that was created, 52-180C, that dealt with the admissibility of sexual conduct in civil cases. We developed a subcommittee to study that statute and to make recommendations about how that statute may find itself into our code of evidence. The subcommittee was made up of Judge Sheldon, Judge Goodrow, Judge Youngblood, and Attorney Brookman. And I have previously talked to Judge Goodrow to sort of walk us through the committee's work and proposals to make the amendments to the code, both not just to with respect to statute 52-180C, but also I think there's a recommendation on section 4-11 in the code. So with that intro, I will turn it over to Judge Goodrow, and then we can have discussion on the subcommittee's work. Judge Goodrow.
Thank you, Justice Mullins. So the subcommittee was tasked with the goal of trying to develop a rule that reflected the intent of 52-180 small c. That's with regard to the admissibility of evidence of a victim's sexual behavior in civil proceedings which involve sexual misconduct. There's the related rule, of course, 4-11, that reflects the intent of 54-86F, as in Frank, and that relates to admissibility of sexual conduct of the victim in criminal proceedings. The subcommittee met on a couple of occasions remotely, and one of the things that we of course noticed was that the statutory language in 54-86F as compared to 52-180C was different in terms of the term sexual conduct or sexual misconduct. So 54-86F references sexual conduct, and that term is used consistently in the rule 4-11. 52-180C, which we were tasked with, refers to sexual misconduct, and the subcommittee felt that it was important to be consistent. So in our proposed rule 4-12, we utilize that term, sexual misconduct, and that may be an issue that may be taken up by the legislature at some point in the future. So in 4-12, which I think has been circulated, our proposed rule, section A of the rule in essence reflects the language of subparagraph A from 52-180C. And it basically indicates that sexual misconduct means acts that are prohibited, and it sets forth the specific statutes as well as any act constituting sexual harassment. It also includes that the term victim includes alleged victim or victims. Section B of our proposed rule reflects the subsection B from the statute 52-180C, and it in essence indicates that evidence is not admissible if it's offered to prove the victim engaged in other sexual behavior, or if it's offered to prove the victim's sexual predisposition. However, section 3 of the rule, again reflecting 52-180C subsection C, sets forth certain exceptions to that prohibition of such evidence. And it indicates that the court may admit the evidence if the probative value substantially outweighs the danger of either 1, harm to any victim, 2, unfair prejudice to any party, and also that evidence of the victim's reputation is not admissible unless the victim places the reputation in controversy. In the commentary, we indicated in essence what I've just said, that the language of the proposed rule reflects specifically those statutory sections. Also, that victim includes alleged victim. And we specifically indicated that we did not set forth the procedural posture of how that evidence would be admitted during a trial or hearing, because subsections D and E of the statute 52-180C specifically set forth the procedure. And I think that is, Justice Mullins, in a nutshell, what the subcommittee concluded.
Thank you, Judge Goodrow. I'm going to try to do this in 2 parts, and I don't think it matters which part we do first, but on section 4-11, there was a small change that the committee recommended. Is that right?
Yes, that's right. I believe to the title of the rule.
And really that just makes clear that once we create, if it passes, once we create section 4-12, that deals specifically with civil cases, and then it clarifies that 4-11 deals with criminal proceedings.
Yes, thank you for that. Yes.
Okay, so why don't we take it up just chronologically, take up 4-11 first, and I would ask if there's a motion to approve the amendment to 4-11 to make it clear that that section applies to criminal proceedings.
I would move, Justice Mullins, please.
Thank you. Is there a second?
Your Honor, not to interrupt you, but it also includes an additional paragraph of commentary, so that would be adopted as well as part of the motion.
Yes, the motion should, thank you, Lori. The motion should include the title and the new paragraph, if you all have it, it's right at the end of the proposal.
Second.
Is there a second? Just Secker seconds. So is there any discussion on these two amendments to 4-11? Judge Prescott?
Is there any guidance from any source as to whether the term criminal proceeding, as we're adding it to the title, would cover a violation of probation proceeding, which is technically quasi-civil? Is it meant to cover that?
That's, if I may respond, Justice Mullins?
Sure.
That's an excellent question, and I don't recall that the subcommittee addressed that. I suppose the same question could be raised with regard to habeas, even though a habeas is technically civil, but, you know, related with criminal. I would ask my fellow subcommittee members to weigh in if my memory is different from theirs.
Well, I think earlier on in the code, we indicate that these rules do not apply in violation of probation proceedings. So that may trump trying to work this rule into a violation of probation proceeding.
Your Honor, if I may, the first sentence of the statute incorporated in the rule refers specifically to any prosecution for sexual assault. So I think it's self-limiting in that sense.
That makes sense to me. Judge Prescott, were you looking to have something added to clarify that, or is that sort of assuage what you were thinking?
Well, I wanted to know initially whether the committee thought about it, and also if there's any, obviously these statutes have existed in some form for a bit, whether or not there's any decisions that have limited or discussed the instances in which they apply. I'm just more looking for clarification than kind of have a strong position about whether or not we should clarify.
I don't recall the committee. I'm sorry. I don't recall the committee addressing violation of probation hearings, but in section 1-1, subsection D, subsection 4, that would be a proceeding involving probation, and in the commentary to that subsection, it specifically says violation of probation proceedings would not be something that to which the code applies.
I mean, that's a very fair point, Attorney Bruckman, but the statute obviously is going to apply one way or the other, and that this provision that we're adding to the code is simply to mirror, I think, the statute.
Could I just ask for clarification, Judge Prescott? So the statute would apply. Are we talking about in a violation of probation proceeding?
No, what I'm suggesting is, even though the code, as Attorney Bruckman points out, doesn't strictly apply to violation of probation proceedings, the statute itself isn't limited in the same way as the code limits its applicability. So regardless of whether the code applies to a violation of probation proceeding, to the extent the statute applies, because it's included with a violation of probation proceeding is included within a criminal proceeding, the statute would apply, in my view.
Mm-hmm.
I don't think my question would prevent us from moving forward. It just really was more for point of clarification for my own sense.
Okay, thank you. Is there any discussion on either on that or on the any other topics?
I was going to say, since the language is, I mean, it probably would need to be resolved under the statute by a court. Right? So we wouldn't want to take any position on it if it hasn't been already. I don't know if it has been, but if it, probably better to remain silent on the question and let a court figure it out. I guess your point is that by adding criminal proceedings, we don't want to put our thumb on the scales. Like that.
Yeah, I agree. It just probably needs to get fleshed out later, either in a case or.
Yeah.
Well, that's sort of what I was angling toward, Judge Prescott. Would your inclination be that we shouldn't include this clarification of this language in the paragraph?
No, I think it's more helpful than it hurts.
Okay.
And if I could just make a comment, this is Judge Youngblood. I suppose one possibility would be instead of the word proceedings in the title, you could use prosecutions, but I just throw that out as a thought. My recollection is that the subcommittee did not take up, we didn't discuss this particular issue that Judge Prescott raised.
Does the statute says prosecutions, doesn't it?
Yeah, I was going to ask whether that first sentence in the statute limits the proceedings to which it applies.
Well, I assume it could be, I don't know at all, but I assume it could be, it applies to any, proceeding in a prosecution. But I don't want to complicate things, but maybe I thought that Judge Youngblood's idea was, was something that may make sense rather than to say criminal proceedings, to say criminal prosecution. But I haven't thought that idea through at all. I don't know what other people think.
In 5486F subsection B, there's language discussing as that certain rules apply if the case proceeds to trial. So I think the intent behind the statute was to be applicable just to trials.
Just to tag along with Judge Youngblood, I think using the term criminal prosecution would be consistent with the language of the statute as opposed to criminal proceeding. I think that would be a wise choice.
Is there any other discussion? I suppose we could, if others agree, we could have an amendment to the motion to, instead of the language being added in criminal proceedings, to be in criminal prosecutions. And that would also require an amendment to the commentary, the paragraph that says in 2021, criminal prosecutions instead of criminal proceedings. So with that amendment, is there any discussion on this proposed rule, proposed recommendation? Okay, so with respect to this first item, section 4-11, with the amendment that the title would be admissibility of evidence of sexual conduct and criminal prosecutions, and the further amendment to the paragraph in the commentary that in 2021 criminal prosecutions was added to the title of this section. Are we ready for a vote? All in favor?
Aye.
Any opposed? Any abstentions? Okay, the ayes have it. with that amendment, with those amendments, this recommendation is approved. So with respect to the second item that Judge Goodrow, thank you for your going over what the subcommittee did and came up with on section 4-12. That is the new section. Is there a motion to approve the recommendation of the subcommittee on section 4-12?
I'll move.
Great. No motion.
I keep waiting. I keep waiting for Mr. Edelman to say something.
It does look like he's on the precipice of saying something very informative. Is there a second?
Second.
Judge Prescott. Okay. Any discussion on the proposed new section 4-12? No discussion, sort of inverted. I thought the less discussion on 4-11 than 4-12, but it is fairly straightforward, and I appreciate your comments, Judge Goodrow. But if there's no discussion, is there a motion to approve this amendment?
So moved.
Second?
Second.
Ready for the vote? All in favor?
Aye.
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 Any opposed? Any abstentions? Okay, so this recommendation of the subcommittee, I thank the subcommittee for their work on this, is approved. And that leaves us with any other business. Is there any other business that anyone has or would like to bring up? Seeing none, I will just update the committee. We at our last meeting, we made some various changes to the code that were approved, and because I thought these particular changes to 4-11 and 4-12 would come relatively quickly in the scheme of things, I think we're going to put the entire package, everything we did with respect to our last changes and this change together in a package for recommendation to the Supreme Court. And so I will keep you posted on that. But now that we've kind of got a nice breaking point to give a substantial package to the Supreme Court, that's what we'll do at this point. So if there's no other discussion, it was great to see you. Thank you for a relatively seamless meeting. And until next time, thank you, everyone. The meeting is adjourned.
Bye, everybody.
Hey, everybody.
Thank you.
Okay.
Bye, everybody.
Bye.